Hello, everyone. Welcome to the Canada Truth Channel, where Canada, the illusion of freedom, and system of control is exposed. This video is called Alberta Has the Sovereign Right, a factual examination of the constitutional problem by Russell Roger Smith, Ottawa, 1937. And he notes on the cover, the information contained in this booklet was placed before Premier Aberhart and members of his cabinet by R. Rogers Smith in the Macdonald Hotel, Edmonton, in October 1935. Russell Rogers Smith spent his life on this, and also his friend and student, Walter Cool, did as well. And both of them have brought this up to elected officials and were ignored because those elected officials did not want to lose their cushy jobs and their pensions and all of the other fringe benefits that come with being an elected official. So it's more important than ever for the people of Alberta to understand this information. This particular pamphlet has to do with the social credit system that the Alberta government was trying to institute in Alberta for the benefit of the people. May or may not be your opinion. However, way back then, 1936, 1937, they were blocked by the federal government. So this has been going on for decades, this battle between Alberta and the federal government. And finally, the people are fed up. Let's get into it. I'm not going to cover this entire pamphlet. I will, however, provide links so you can read it for yourself. And once again, listen to how relevant this is today. Let's see here. Although the information in this booklet is important to all provinces and all Canadians, it is vital to the people of Alberta, particularly the elected members, because Alberta elected representatives committed to introduce a social credit regime. Throughout the country, Canadians are intently watching Alberta. Why do they stall? Why do they not put social credit into effect? They talked enough about it. Is it that they do not know the relationship of Alberta to the Dominion? These are questions being asked today. They're still being asked today. Oh, this is slow. By checking the information in this brochure, it can be proved that Alberta has the sovereign right to issue and use its own credit. If, however, the members do not do this, they can be justly accused by their electors of incompetence or worse. The facts are taken from statutes at large, from the archives, and from original historical sources, which are irrefutable. I desire to express my gratitude to the various constitutional authorities who have assisted me in checking and verifying the facts contained herein. Russell Rogers Smith had unlimited and unprecedented access to all the archives. Excuse me. The reason the request of the colonies to be permitted to form a federal union was refused by the Colonial Office in 1867 was because the United States was pressing Great Britain for a settlement of claims for indemnity arising out of the actions of the British Navy during the Civil War, for which Great Britain acknowledged responsibility in the Treaty of Washington. The terms of this treaty could only be settled by retaining Canada as a colony. There are a whole bunch of very interesting historical facts in here, but for the sake of time, we're going to jump ahead. During these eventful and hectic times, our delegates arranged to leave Canada July 30th, 1866, to take the Quebec resolutions to London. These resolutions were for the federal union, were to be returned to the people for their ratification. See Section 70. We were to have a government of the Canadian people. Tilly Tupper, Archibald, and the maritime delegates left as arranged. Tilly to be chairman. The Honorable John A. Macdonald wrote him on the eve of his departure. On no account change any of the provisions of the resolutions, for if you do, it may mean an entire reopening of the negotiations with the provinces and the consequent disruption of our plans. Sorry about the writing on this. It is what it is. A draft was sent to Lord Carnarvon, Secretary of State for the Colonies, by Honorable John, December 26, 1866, and he had a reply dated the 28th, stating that the draft was being sent to the printers to be printed. This draft of the bill, which contains the following repealing clause, was rejected by the Colonial Office. From and after the Union, all acts and parts of acts passed by the Parliament of Great Britain, the Parliament of the United Kingdom of Great Britain and Ireland, the Legislature of Upper Canada, the Legislature of Lower Canada, the Legislature of Nova Scotia, or the Legislature of New Brunswick, which are repugnant or inconsistent with the provisions of this act, shall be, and the same are hereby repealed. It is not difficult to understand why the Colonial Office objected to Canada's request for self-government. It would have been a suicidal policy on the part of Great Britain to grant the provinces of Canada the right to create a federal union. It was imperative for the best interest of Great Britain that Canada be retained as a colony so that they could settle the terms they had tentatively agreed to in the Treaty of Washington. Some of the provisions of the Treaty of Washington are here. Had the Colonial Office granted our request for federal union, the Imperial Parliament would have had nothing to barter with in their settlement with the United States, as well as the possibility that after creating a federal union, Canada would join the United States, which at the time was considered an enemy. The status of Canada has since been changed by an act of the Imperial Parliament, the Statute of Westminster, December 11, 1931. Section 11 of the Act states that Canada is no longer to be considered as a colony and recognize Canada as an equal with Great Britain as a member of the British Commonwealth of Nations. How did we get the BNA Act 1867? In a communication dated December 28, 1866, Lord Carnarvon acknowledged receipt of the draft of the bill submitted by Honorable John A. Macdonald, chairman of the Canadian delegates, and told him that he was sending the draft to the printers to be printed. This was done as we have in the archives at Ottawa printed copies of this draft. Each delegate from Canada signed his own copy. The British North America Act passed a second reading of the House of Commons without being printed, which is evident by the Hansard, February 26, 1867. You want your factual evidence? Here we are. Between December 28th and February 9th, following, we are informed by Sir Frederick Rogers, Under Secretary of the State for the Colonies, they held many meetings at which I was always present. Lord Carnarvon was in the chair, and I was rather disappointed in his power of presidency. I had always believed, and the belief has so consolidated itself that I can hardly realize the possibility of anyone thinking the contrary, that the destiny of our colonies is independence, and that in this view, the functions of the colonial office is to secure that our connection, while it lasts, shall be profitable to both parties, and our separation, when it comes, as amicable as possible. This opinion is founded first on the general principle that a spirited nation, and a colony becomes a nation, will not submit to be governed in its internal affairs by a distant government, and that nations geographically remote have no such common interest that will bind them permanently together in foreign policy, with all its details and mutations. The minutes of the meeting at which the British North America Act was drafted have never been made public. I wonder why. Why do they have something to hide? Referring to the Hansard, we find that the bill was introduced by Lord Carnarvon to the House of Lords February 9, 1867, in the following words. The bill opens by reciting the desire of several provinces to be federally united. The actual words of the preamble are, by reason of the request of the colonies for federal government, it is expedient, therefore, that they have laws and regulations to guide them. Lord Campbell, leader of the opposition in the House of Lords, in opening his speech at the second reading of the bill, February 26, 1867, said, "The bill is founded, I believe, on what is termed the Quebec Scheme of 1864. Our lights indeed may be imperfect upon this part of the subject, and I will not dwell upon it. But one thing is clear, the preamble of the resolution comes before us in clear and perfect authenticity. There is no reason to doubt that the House of Lords believed they were enacting a measure that would permit the provinces to form a federal union. The page which sets forth the enunciation of the motives for which the measure was enacted is not part of the printed copies of the Act received in Canada. Instead, we have a substitution. Whereas the provinces of Canada, Nova Scotia, New Brunswick, have expressed their desire to be federally united into one dominion. This is not a true statement and discussed under the heading, What is the BNA Act? So the fraud starts here, ladies and gentlemen. Right from inception, we did not get the act that passed the British Imperial Parliament. Let us now hear what the Privy Council has to say. Lord Watson, chairman of the Privy Council Maritime Bank case, 1892, recognizes the object or raison d'etre of the measure, as stated in the preamble, as most important. The object of the act was to create a federal union, entrusted with the exclusive administration of affairs in which they had a common interest, each province retaining its independence and autonomy. The object of the act supersedes in importance any subsequent section. Y was the page which contains this deleted from the printed copies circulated in Canada. It was to twist the measure so Canada should be retained as a colony. And there the illusion begins, ladies and gentlemen, based on deliberate deception and fraud. After passing the House of Lords, it was taken to the Commons. February 26, 1867, the debate there centered around the appropriation to the Intercolonial Railway. The purpose of the act was not discussed. It evidently was assumed that this had been debated in the Lords. One member asked the government, why all the haste in enacting this measure? I'm not sure I will have anything against it, but it affects 4 million people, and we should have the opportunity to study the measure, which is now in second reading, and it has not been printed. Sounds reasonable to me, ladies and gentlemen. After passing the Commons, it received the assent of Queen Victoria, March 29, 1867, to become effective in Canada, July 1st, 1867. Strenuous opposition was expressed by Nova Scotia. A protest against the act was signed by 30,000 people, and in the election of May, Dr. Tupper's government was defeated. In a House of 38 members, Stuart Campbell of Guysborough County and Dr. Tupper were the only two returned. Tupper resigned. Joseph Howe and 8 members were delegated to place a petition before the Imperial Parliament that Nova Scotia be relieved of this measure or a Royal Commission of Inquiry be appointed. Dr. Tupper, a lifelong political enemy of Howe, followed him to London and going to his hotel said, "Nothing I can say will deter you from placing your petition before the Parliament, but they will not grant your request. When they refuse, come back to Canada and take a cabinet seat at Ottawa, where we will do the best we can with what we've got." Does that sound familiar, ladies and gentlemen? That's the position we're in right now. And, once again, believing in a system that's based on deliberate deception and fraud to act legally, lawfully, and honorably is insanity. Howe was dumbfounded, for he previously had thought that Tupper, who was one of the delegates to London dealing with the Quebec resolutions, was partly responsible for the drafting of the British North America Act. He induced John Bright to place the petition before Parliament. It was, as Dr. Tupper predicted, defeated by votes being 183 to 87. Nova Scotia was compelled, against her wish, to become a member of the Dominion. In a speech on leaving London, Howe said, "We go home to share the perils of our native land, in whose service we consider it an honor to labor, and whose fortune, in this darkest hour of her history, would be cowardice to desert." What is the British North America Act? The British North America Act is not and has never been a legal and valid as a constitution of Canada. Canada has no constitution. The Act is a private bill conceived and drafted by the Colonial Office and enacted into statute by the Imperial Parliament, uniting 4 colonies of North America into one colony, called the Dominion of Canada. Last year, 1936, the Imperial Parliament enacted a bill amending the Constitution of the island of Malta, a colony in the Mediterranean. Students of law recognize that this act as a private bill in relation to the Empire as it affected only Malta. The British North America Act is placed on the same category as it affected only Canada. A private bill must always have a preamble, the recitals of which must be proved. This is a substantive enumeration of the motives which impelled the Parliament to enact the statute. It is the most important part of the Act, superseding in importance any of the subsequent sections. The Act must read and be construed as a whole, although one section may bear a wider and another more limited meaning. The Governor General is the government, with power to appoint a council to aid and advise him, or he can remove them from office at his discretion. The custody of the Great Seal is granted to him. The power to appoint judges, justices of the peace, commissioners, deputies of himself, lieutenant governors of the provinces, members of the Senate. He can remove any person from office exercising any special power in our Dominion, including the Premier of Canada and the Speaker of the Senate. Insofar as the provinces are concerned, he takes the place of the Queen and Secretary of State. In other words, any legislation of the legislatures of the province can be disallowed by him. Further, the provinces cannot refer any legislation so disallowed to the Imperial Parliament or the Crown. There was no confederation. There is nothing in the historical record which can be cited to support the story of confederation. There is nothing in the Act to alter in any essential respect the colonial relationship or to weaken the Crown's headship, nor is there anything in the Act to indicate a surrender in any degree of that fundamental principle of the British government, full legislative and executive power to govern over and throughout the British Empire. An examination of the historical record shows that fraud was recorded in at least 4 instances in relation to its enactment. This is not sufficient to remove the statute. Fraud must be proven from the wording of the Act itself and in the manner in which the words are used. This is the law in relation to statutes. Is the British North America Act fraudulent from the words and the other manner in which the words are used? It is. A federal union must be free and sovereign, whereas a colony must be subservient. No country could be both at the same time. The words are opposite in their meaning. There is no power in heaven or earth that can pass a law arbitrarily create a federal union. It must be a mutual agreement between those adopting their constitution. No agreement of any kind has ever been signed between the provinces of Canada. I know what you're going to say out there. What about the Charter of Rights and Freedoms and the Canada Act? Well, it's all based on deliberate deception and fraud. No contract in law can stand on fraud. That is a contract between the provinces and the federal government. As an enunciation of motives, articulating the Parliament to enact their statute, the words federally united into one dominion, and the matter in which the words are used constitutes fraud, and brands the British North America Act as a fraudulent measure. It is impossible to be federally united and a dominion at the same time. Search for a certified copy of the Act. My researches on this subject led me to Ottawa, where I examined the documents in the archives. These, the Quebec resolutions, and the Kingdom of Canada draft of a bill, both drafted by our Canadian representatives, are carefully preserved. I desire to publicly thank Colonel Hamilton, custodian of the records, for his assistance. At my request to be shown a certified copy of the BNA Act, he regretted that he had no such copy in the records, but obligingly arranged an appointment for me with M. Lemaire, clerk of the Privy Council. Not having this document, Mr. Lemaire instructed his secretary to conduct me to the Governor General's office, where I was presented to Mr. Pierria, Chief Secretary. Not finding this act, Mr. Pierria handed me a note for Mr. Hardy, Parliamentary Librarian. At the library, I was informed that this was a very valuable document, and no doubt I would find it in the office of the Secretary of State. Mr. Coleman, the Undersecretary, delegated 3 of his assistants to search the premises. Not being able to find it there, Mr. Coleman directed me to Dr. Bouchain, Clerk of the House of Commons. "Why would I have it?" was the doctor's reply to my request. "No documents are kept here. But you had better see Mr. Blount, Clerk of the Senate. He has a vault where important papers are under lock and key." Mr. Blount informed me, however, that he did not know of it, but would open the vault if I would care to look. We descended with an assistant to a room below the Senate chamber, and with the aid of the stepladder, lowered 2 large cases marked 1867 and 1868. Not finding the certified copy, which is presumably the charter of the Dominion government, I suggested that it might have been destroyed in the fire which burned the main building in 1916, but I was assured that all the documents had been saved. Some had been discolored by water. All that was lost were some pictures in the galleries. So the foundational document, the charter of the Dominion government, a certified copy never came to Canada. Now, why is that? It would show the fraud, number one, and number two, it was never a Canadian document. Returning to his office, I inquired if the Senate Journal had any reference to the act being placed before that body. We examined the journal and another large volume which contains a proclamation from Queen Victoria with the names of the first senators, also an extract covering the executive activities of the Senate without success. "Was this act ever placed before Parliament?" I asked. "You will have to ask Dr. Bouchain," was the answer. Returning to the Commons, Dr. Bouchain made an exhaustive search of his records without finding any reference to the act in his journal. "Well, doctor, I was informed that we had no certified copy of the act in Vancouver by the Chief Justice of British Columbia, but was assured that I would find it in Ottawa. If it were in Canada, it would no doubt be in Ottawa. So I think we can assume, for the purposes of my investigation, that no certified copy of the British North America Act was ever brought to Canada. Is that so?" "I'm very much afraid that you are correct," was the doctor's reply. "The first page was left out. Why?" After the act by the British Parliament, March 29, 1867, printed copies were brought to Canada. These, however, did not contain the first page, excuse me, which sets forth the enunciation of the motives and the purpose of the enactment. Why was this most important page deleted? This is a vital question and can be best settled by having a certified copy sent to Canada. The provinces of Canada will then no doubt form a confederation or a federal union as they wish and as set forth in the resolutions of 1864. No agreement was ever signed by the provinces of Canada or their representatives to center power on a central government, which is the only way a constitution can be created. First, representatives of the provinces are appointed or elected to a constituent assembly where the agreement is drafted. The agreement, after ratification by the electors, is called a constitution. Let us examine the difference between federal union and a colony. The definition of a federal union, as given by our law dictionary and the only definition acceptable in a court of law, is a union of sovereign states mutually adopting a constitution. It is not enough that they be free to unite, they must also be free to reject. This is the meaning of the word mutually. They must also adopt or ratify the agreement by a plebiscite of the people, for the people under God are the origin of all just power. This was a fundamental provision in the Wittegemot in early Parliament of the Anglo-Saxons. They had the power to depose their king. This was again enacted by the House of Commons on January 4th, 1649. On January 30th, 1649, Charles I lost his head. That settled the argument. In order that all courts should define words in the same manner, the Interpretation Act was passed in 1889. Section 18, paragraph 3 defines a colony in these words. The expression of colony shall mean any of Her Majesty's dominions exclusive of the British Islands and of British India, and where parts of such dominions are both under a central legislature and local legislatures. All parts under the central legislature shall, for the purpose of this definition, to be deemed one colony, the Dominion of Canada. As Canada was the only dominion with a central legislature and local legislatures in 1889, it is evident that in a court of law, Canada could not be deemed to be other than a colony. The Statute of Westminster, December 11, 1931, has since changed our status. Section 11 says, notwithstanding anything in the Interpretations Act, the expression colony shall not in any act of Parliament of the United Kingdom passed after the commencement of this act include a dominion or any province or states forming a part of a dominion. Canada was a colony before the commencement of the act and never a confederation. It is not generally known that the Native Sons of Canada, and more particularly Assembly Number 2 of Vancouver, drafted the resolution which is the basis for the Statute of Westminster, of which a copy is in Parliamentary Library. Russell Rogers Smith was part of the Native Sons of Canada. The statute gives us a status of equality with Great Britain. They have no more right to issue letters patent to a Governor-General to govern Canada than Canada has a right to issue letters patent to a Governor-General to govern to govern Great Britain. In 1867, the Colonial Office drafted a charter which was enacted by the British Imperial Parliament in a private bill or statute uniting 4 of these colonies into one colony without altering their status of their relation to the mother country, Great Britain, retained all executive power or legal sovereignty after the Union as before. In other words, they remained colonies of Great Britain with 1 Governor General instead of 4, and letters patent granting him the power to govern and a committee of His Majesty's Most Honourable Privy Council to administer affairs in connection with the United Colony. As the New England colonies were called dominions, and as Wales was a dominion until the reign of George III in his United Colony, this United Colony was called a dominion. In 1931, the Statute of Westminster altered this relationship and granted to Canada the right to self-government, and in order that a federal union they previously requested could be formed, granted to each province the sovereignty to create a federal union. This power was granted to them so that they could create their own government, the same as the Commonwealth of Australia, the Union of South Africa, or the Irish Free State. How has the BNA Act been used? The BNA Act has been used as though it were a constitution of Canada, which it is not. It has been used to govern Canada, and it was the intention of Lord Carnarvon that the Colonial Office that it should do so, but it was not the idea or intention of the House of Lords or the Commons which enacted it. The Parliament thought it was to be a guide to the creation of a federal union. They knew this could only be attained by an agreement between the provinces, so they were not particularly concerned. As has been shown in a previous section, the provinces were united into one colony, and the colonies cannot decide on an agreement, for they are not free to sign anything. That is why, after the act was passed, it was never returned to the provinces for their assent, as the provinces would necessarily have to be free before they could legally unite or incorporate into a federal union. The Statute of Westminster provides a paragraph for this purpose. Paragraph 2 of Section 7, which is discussed in the section, the Statute of Westminster grants autonomy. Although the object or raison d'etre of the Act is to provide a guide to the creation of a federal union, this scope of the Act has not been exercised. A legislature of a province may pass acts to incorporate a locality or district into a municipality, but the actual incorporation must be accomplished by the citizens of the locality. This was the idea the British Imperial Parliament accepted when they enacted the BNA Act. By the terms of the Act, the Governor General is the government. He received his letters patent to exercise the powers of the Act from the Clerk of the Crown in Chancery. The latest letters patent were issued to Earl Bessemborough and signed by Sir Claude Schuster, March 23rd, 1931, 8 months prior to the enactment of the Statute of Westminster, December 11th, 1931. As Canada has been raised by statute to the accepted constitutional position of equality with Great Britain, the imperial government could not grant further letters patent. In a cable to the imperial authorities in October 1935, I myself protested any letters patent being issued to Lord Tweedsmuir. He received none. Without these all-important letters patent, the powers granted to the Governor General in the BNA Act cannot be legally exercised, which once again I have shown you in the exposed the Governor General fraud. In the Statute of Alberta, there is an act, the Constitutional Questions Determination Act, which provides that any question touching on the Constitution of Alberta or where there is conflict between the province and the Dominion, the case may be taken to the Supreme Court and any person or class of persons are entitled to be heard. Sovereign power is independent of all powers from without. It is paramount over all action within. Following is a synopsis of evidence presented before the special committee convened in 1935 to investigate the British North America Act. Convened at the House of Commons February 26, 1935. Excerpts from the evidence of Dr. Skelton, Undersecretary, State of Internal Affairs, Dr. Oliver, Joint Law Clerk of the House of Commons, W.P. Kennedy, Professor of Law, University of Toronto, N. McLean Rogers, Professor of Political Science, Queen's University, Arthur Bouchain, Clerk of the House of Commons, Dr. Skelton, Undersecretary of State for External Affairs. Now, it may be said, why not trust to growth of convention or custom altogether for the necessary changes in our Constitution? The obvious answer, I think, is that the process is too slow and is applicable only in cases where unanimity has been reached. Sorry, it's been a long day. No other country in the world looks to the Parliament of another country for shaping its constitution. This solution could only be supported if we believe that Canadians are the only people so incompetent that they cannot work out a solution of their constitutional problem, and so biased that they alone, among the peoples of the world, cannot be trusted to deal fairly with the various domestic interests concerned. It is not safe to leave the question open, ambiguous, indefinitely, for at any time a dispute on a concrete issue may arise. Sound familiar, ladies and gentlemen? To retain permanently the intervention of the Parliament of the United Kingdom is either superfluous or dangerous. Dr. Oliver. Furthermore, our Constitution is a law adopted by the British Parliament, exercising its incontestable right of sovereignty towards its colonies. This explains the fact that the British North America Act is not a reproduction of the Quebec resolutions. England was free to agree to the resolutions or to disregard them entirely. Instead, they chose to deceive people. Dr. Kennedy, I think we have got to get away from the idea that the British North America Act is a contract or treaty. I do not want to go into that, but it is true that neither in history nor in law, the British North America Act is a statute and always been interpreted as a statute until the federal government of Canada got on it and they treat it as the Constitution of Canada, which it is not. Never was, never will be. Suppose now we assume that it's necessary to have constituent powers in Canada, powers to change the Constitution. I approach that problem from two angles. First of all, I want to break the British North America Act up. We have got to ask ourselves, is the dead hand of the past to be constantly laid with numbing effect on the body politic? That is really what it amounts to. If we in Canada are not capable of interpreting our own constitution, we should not have a legislature at all. Excuse me. Professor Norman, I am thoroughly convinced that the British North America Act is not a pact or contract, either in historical or legal sense. A question by Mr. Cohen. You go back to this. Your start is another interprovincial conference? I'm afraid it is. I see no feasible alternative. And Honorable Lapointe backs that up. There is no doubt about it. Dr. Bouchain, Clerk of the House of Commons. It is quite true that if we apply the British North America Act, the principles followed in the interpretation of statutes, it is not a compact between provinces. It is an act of Parliament which does not even embody all the resolutions passed in Canada and in London prior to its passage in the British Parliament, where certain clauses that had not been recommended by the Canadian provinces were added. The Statute of Westminster has altered our status. What we want is a new constitution. The new constitution must leave nobody with a grievance. The spirit of conciliation should predominate. For these reasons, the task must be entrusted to an independent body in which all elements of the country will be represented, not the Canada Act introduced by Pierre Trudeau and Queen Elizabeth II to cover all this shit up and make Canadians believe that we have a constitution and friggin' rights granted to us by the government. I want the Assembly to sit in a city in the West. It would not be necessary for a delegate to be a member of Parliament or a provincial legislature. In fact, it's imperative because these people have conflicts of interest. I would suggest that the Assembly do not sit in Ottawa in order that it may not have the appearance of being dominated or even influenced by the Dominion power. And as the Western provinces are of such paramount importance in the country, I suggest the best city for the representatives to gather would be in Winnipeg. Center of Canada? Sounds reasonable. Whether our country should be changed from a dominion to kingdom is also a subject which might be discussed. I would suggest the country could be called the Federated States of Canada. There have been many disputes about provincial rights since 1867, and it seems certain that when a new constitution is drawn up, the distribution of federal and provincial powers will have to be modified, which of course the federal government doesn't want, so they can maintain Canada, the illusion of freedom and system of control. I submit that appeals to the Privy Council should be dealt with by our Constitution. This method would preserve the principle of taking our cases to the highest tribunal without going out of our own country. If you will allow me, Mr. Chairman, I will just make another suggestion. If we have a constituent assembly and if we discuss the making of a new constitution, I think it is an anomaly that Dominion affairs should, to a certain extent, be subject to provincial authority. I would suggest that we have a federal district taking in about 25 square miles on each side of the Ottawa River. that would be eminent domain once the newly formed federal government was constituted by the people and the provinces. I would not have any minority rights discussed. There is nothing more dangerous in Canada than a discussion of minority rights. A discussion of them would wreck the whole constituent assembly. I think the time is right for a change in the Constitution. I do not think we need much publicity in order to draw the attention of the people of this country that the British North America Act is inadequate. And here we are in 2025, and they're still relying on that fraudulent dead document to constitute their authority. How did we get the Statute of Westminster in 1931? Summarizing and consolidating the results of their meeting from 1911, the Imperial Conference of 1926, composed of the representatives of all the dominions and of Great Britain, agreed to draft a bill to be presented to the Parliament, which would enact a measure to put into effect the accepted constitutional positions that each of the dominions had an equality of status with the United Kingdom. Canada, without question, may be said to have taken the leading part in these conferences, and in 1926 our Prime Minister, the Right Honourable William Lyon Mackenzie King, approved the first resolution crystallizing the findings of the previous conference and its synopsis of the accepted opinion and attitude of the Canadian people toward the Empire and the United Kingdom. It covers all points which are incorporated in the Statute of Westminster, particularly that Canada should be elevated constitutionally to a position equality with the United Kingdom. States the position of Canada in regard to assisted immigration and Canada's natural resources, our previously expressed attitude on imperial defense, that the method of appointment of the Governor General of Canada is ripe for a radical change, more in consonance with national dignity, which we have totally forsaken, that the channels of communication between Canada and other countries should be direct. As to this resolution was drafted, sent to our Prime Minister by Assembly Number 2 of the Native Sons of Canada, Vancouver, BC, prior to his departure for the 1926 conference. The last paragraph is quoted verbatim. This Assembly is convinced that so long as the present anomalies of Canada's status continue, the advantages to Canada from participation in imperial conferences are largely negative. The conference is built on a constitutional fiction that all the representatives meet as equals. The test, what is Canada constitutionally, is the true test, and until Canada, either by her own act or by an imperial concession, attains sovereignty as in the independent nation under the Crown, with international recognition, her position in respect to Britain's wars, neutrality, and her international relationship in general will remain clouded and obscure. That position will be and remain both constitutionally and internationally that of colonial status. Mere rhetoric cannot overcome this inescapable fact. Russell Roger Smith was one of the authors of the Statute of Westminster, and therefore an absolute expert for the sake of time, I'm jumping ahead. The Statute of Westminster grants autonomy. As Dr. Bouchain states in his evidence, the Statute of Westminster has altered our status. Section 11 states that after the commencement of the Act, no dominion or nor province or state forming a part of a dominion shall be considered to be a colony. It is acknowledged that the status of Canada before the commencement of the Act was that of a colony. And it may be said in this connection that until the provinces of Canada have been elevated to a position of autonomy, they had no voice in stating how they should be governed. The Statute of Westminster altered our status by granting complete autonomy to the provinces. Dr. Bouchain, once again, he's the Clerk of Parliament, to state that because provinces of Canada have used the BNA Act for 70 years, or because the statute of limitations, or for the reason that is the Act has been accepted as the cornerstone of Canadian law and legislation, that the BNA Act is a constitution is not correct reasoning. Still to this day. First, because the provinces of Canada do not use the BNA Act as a whole. It is an instrument for the exercise of the powers of the Governor General. It was not accepted by the provinces at the time since its enactment, but has been protested by them on many occasions. We may use the Act as a guide to the creation of Constitution, or on the basis of an agreement between the provinces, as this was the object or the intention of the Parliament which enacted it, or we may disregard it entirely if we choose. Why? Because the provinces of Canada are completely autonomous today. Each province is a political unit without a political superior. Although the statute affects other dominions as well as Canada, it also extends autonomy to each of the individual provinces of Canada. Paragraph 2 of Section 7 states the provisions of Section 2 of this Act shall extend to laws made by any of the provinces of Canada and to the powers of the legislatures of such provinces. The provisions of Section 2 are those which grant autonomy. Autonomy is not divisible. Either you have it or you have it not. Why were these autonomous powers not granted to the states of Australia individually or to the states of South Africa? Because these states had created their own constitutions before the commencement of the Statute of Westminster. Granting autonomy to Canada as a whole was not sufficient in the opinion of the Imperial Parliament which enacted the statute, for they knew it would be necessary for the provinces to grant their power to a central government, and this could only be done when they were free. Although Canada, and more particularly British Columbia, took the lead in placing before the Imperial Conference the reasons for the enactment of the Statute of Westminster, Canada has not taken advantage of its provisions because they didn't properly inform the people of the provinces, because they wanted to maintain their control and ability to rape and pillage the land and people of Canada. The other dominions affected have taken advantage of this measure, and although remaining within the empire, have their own constitutions. The Irish Free State has no Governor General. The Premier now acts as the representative of His Majesty. South Africa is no longer tied to the apron strings of grandma. A parliament of a dominion is not a central legislature of a colony, and no alteration of its charter can make it so. Section 3 and 4 of the Statute of Westminster do not refer to the central legislature at Ottawa. This can only be construed as it states, and a parliament respecting the provinces of Canada must be one whose charter is granted by an agreement between the provinces, or in other words, created by them. He goes on to talk about the Federated States of Canada, which still hasn't happened. And for the sake of time, I'm not going to go through a lot of this. I'm just going to finish off with this paragraph. The story of Confederation is a myth, and those that think Sir John A. Macdonald was the father of Confederation know little about this question. In a letter to Lord Knutsford, Secretary of State for the Colonies at the time of the first meetings were held between the states of Australia regarding a federal union in 1888, Sir John expresses his regret for the defeat of the 1867 in the following words. If the statute, the BNA Act, had only followed the Canadian draft of the bill, Australia ere this would have a government similar to the Kingdom of Canada. And there you have it. The next step is an interprovincial conference where an agreement can be reached upon the powers to be conferred on the central government, the powers which must be retained by the provinces. So once again, for all of you out there who are going to say, yes, but this happened with the Charter of Rights and Freedoms through the Canada Act, which, as you can see, right from the inception, was based on deliberate deception and fraud and cannot stand in law. So there you have it, ladies and gentlemen. Please share this information, use the links I provide, and read this entire pamphlet. It's only 24 pages for yourself. It's amazing, and it's history. This is the true history, not the history that we've been taught and believe in, but the true history. So, that being said, as always, I will provide links for this information, but you can find it here. And when I was looking for links to share with you guys, lo and behold, it's been republished and available on Amazon. Unbelievable, $22.97. I'm going to order a hard copy for certain, although I'm not sure it's going to be available in Canada. And just as a last tidbit to reiterate that de facto law is recognized in Canada, here we have the Criminal Code, obedience to de facto law. No person shall be convicted of an offense in respect to an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. So there you have it. They even recognize it themselves. However, they don't allow us to recognize it. Please use the links I provide. Develop your own level of knowledge and understanding on this material. That way you can share it with other people and do it in a properly educated and informed manner. Thanks for watching.